Good afternoon. Thank you all for coming. I'm delighted to see you all. I'm Jacqueline Kennedy. I'm the Executive Director of the Harvard Law School Library. Thank you all for being with us today for our book talk. Before I start, I want to thank the Dean's Office and our co-sponsors, the Human Rights Program here at Harvard Law School and the Harvard Law School Project on Disability. Today's talk and question and answer period are being recorded. They'll appear on our YouTube channel probably early next week. So down to business, it's my pleasure to introduce today's moderator for our discussion of the UN Convention on Human Rights of Persons with Disabilities, a commentary. For those of you who have taken international law, you know that this is an important book. William Alford is our moderator today. He chairs the Harvard Law School Project on Disability, which provides pro bono services on issues of disability in a variety of nations. He's also the Vice Dean for the Graduate Program in International Legal Studies and is the Jerome A. and Joan L. Cohen Professor of Law here at HLS and a very good friend of Michael Stein, our author. So I'll turn it over to Bill for further introductions. Thank you. Thank you all for being here.
Thank you, Jocelyn, and thank you to the library for yet another in what's been an excellent series of book launches. It's a great addition to the law school scene. So I am delighted to be chairing this session. We live in a postmodernist age in which people talk a lot about the indeterminacy of language, and I think that makes it all the more important that we have this extraordinary accomplishment. I can barely lift it. Here it is. A volume that is incredibly nuanced and fair-minded and thoughtful, also surprisingly readable for something of this size and character. On each of the 50 articles of the CRPD, the first human rights treaty of this century, and one in which Professor Stein played a very important role, very important shaping role. It also indeed even has an article on the optional protocol. Now, one reason this volume is so nuanced and so thorough and fair-minded is it represents the work of no fewer than 55 different individuals from 22 countries, at least, across 6 continents. And although a majority of the authors are people in law, it also includes contributions from people in education, in psychology, in social work, in health sciences, and other disciplines. And not only the writing of academics and academic lawyers, but also people who have been officials in national governments, people who have been international civil servants in multilateral organizations, activists, NGO participants, and of course, many individuals with disabilities themselves. So as befits so rich in varied a book, today we have a terrific panel to guide us, indeed one that itself is multidisciplinary, and then we'll hear after the panelists from Professor Stein and have time for questions. So we'll start with our guest, Professor Jackie Bhabha, and Professor Bhabha is on 3 faculties here at Harvard, at the law school, where she's the Jeremiah Smith Lecturer, at the School of Public Health, where she's Professor of Practice with respect to human rights, and at the Kennedy School. And she has a long and very distinguished record in the area of human rights. She's a native of England, was a first at Oxford, earned her law degree in London, and has been here at Harvard with us after was about 15 years at the University of Chicago, Jackie. So Jackie, thank you for coming across the river to enlighten us.
Thank you very much, Bill. Thank you to Michael for this amazing contribution to scholarship and to advocacy and to human rights. And thank you to all of you for being here. So I am not an expert on the CRPD, but I do very much admire the trend-setting work that Professor Stein and others have done in thinking about the relationship between human rights violations and violations of dignity. Dignity is a central concept in the human rights world. And yet it's a very poorly understood concept. It's not defined, but it somehow reoccurs in every treaty and in many discussions. And I think that the work that colleagues working on disabilities have done to really instantiate and put flesh on this notion of dignity has been enormously important for the human rights field as a whole. Professor Stein asked me to talk a little bit about the areas that I do know something about, which are really issues to do with migrants and refugees and issues to do with children and young people. So I have a slightly random set of comments bringing together those two broad topics. 2 months ago, I visited a Rohingya refugee camp in Cox's Bazar in Bangladesh. I was interested in, and our centre is interested in, working on issues to do with education, skill training, and well-being of children and young people who have fled from what some people are calling a genocide and others are calling ethnic cleansing. And so I visited places where education was taking place. And I use this clumsy word, places where education was taking place, because actually the Bangladeshi authorities have decreed that Rohingya children are not entitled to go to school. Not only are they not entitled to go to school outside the refugee camp where they are, but even in the refugee camp, they are not entitled to be given access to schooling. Instead, what is being provided by the international community is something called learning centers. Learning centers where there is something approximating education being given, but the education happens in Burmese or Myanmarese or in English, but the international community is forbidden from giving education in Bengali or Bangla, the local language, or in the Chittagonian accent, which is the accent or the dialect that the Rohingya speak, because Rohingya are not recognized as refugees. Bangladesh has not recognized the Refugee Convention. I won't go into that. And Bangladesh wants to signal to the international community and to Myanmar that it is not a permanent destination for this and any other future massive group of expelled residents and citizens, should be, of Myanmar. When I entered one of these learning centers, there was a child with a severe disability in one of the classes who I noticed immediately, but she was one of many others. And the children were kind of performing for me, the visitor, singing songs and reciting meaningless nursery rhymes in English, which they didn't understand, just you could tell from the cadence of the words, you know, twinkle, twinkle, little star, why, etc. You get the idea. But I noticed this girl, and I thought, oh, well, that's good. At least, you know, kids with disabilities are in these learning centers. And that seemed to be in conformity with Article 7 of the Convention, which says states parties shall take all necessary measures to ensure the full enjoyment by children with disabilities of all human rights and fundamental freedoms on an equal basis with other children. And also specifying that the best interest of the child should be a primary consideration. So this is just completely in conformity with the Convention on the Rights of the Child. But then, just as I noticed this and was kind of appreciating it, my guide pointed to the girl with the disabilities, made her sort of stand up as best she could and said, you see, we even have these sort of children in the class. And I was just horrified. And it really reminded me of conversations with Michael and thinking about stigma. And so I didn't really let on, but I thought this is the example of you know, you've made some steps, the girl's not left in her heart. But here she is being made to sort of stand up and kind of being portrayed as a kind of oddity, as this kind of strange kind of outsider in the classroom to a stranger who she's never seen before. So this tension between protection and paternalism, which I think is one of the ongoing issues that the, you know, the disability rights movement is contending with. So clearly only part of the legal obligation to really pay attention to the best interests of this child were being addressed. And so this led me to think about how many other refugee children are in this kind of between the devil and the deep blue sea of either being excluded completely or being included in a way which really emphasizes their disability, emphasizes their difference, and is really an act of discrimination. So really what this guide was signaling, not only to me, but to the children, was she's different, you know, she illustrates something good that we're doing, but this isn't sending the right message, I thought, to her peers in the classroom. So clearly, targeted intervention is necessary. Skill development of youth, of all youth, including youth with disabilities, is necessary. But the way of providing this has to be thought through in a much more holistic way than I saw on that occasion. And I thought I'd tell you about another project which I have encountered, which takes place in India, in the Indian state of Andhra Pradesh, where there is an NGO called Youth for Work, which works with children and youth with disabilities, trying to give access to employment. And the idea here is that if young people with disabilities are working, this is an important contribution to inclusion. It's an important contribution to status within their families, within the community, and it's an important way of rectifying past discrimination. So this organization has various training centers, including a center for people with disabilities, and they rely on an Indian government database called Software for Assessment of Disabled for Access, Rehabilitation and Empowerment, wonderfully Indian clunky phrase, reduced to SADRM. And within a year, Andhra Pradesh created employment and financial independence opportunity for over 1,000 youth with disabilities. So it had a transformative impact. But here again, this tension between protection and advancement of rights and some sort of if not paternalism, certainly some sort of qualification of a fully holistic rights-based approach. So one of the students who had then been included in this said, till we came to the center and started learning English, we had no idea how important it was for our self-confidence and our well-being. Now, when I go home to my village and I speak English so well, everyone is surprised and they treat me differently. But she says, the work is repetitive, it's boring, it's unenlightening, and she's exhausted at the end of the day. And so again, there's this mixed balance sheet. So my sense is there's a really arduous, uneven terrain where accommodation, inclusion really presents ongoing challenges. The last kind of example I want to give is a project that we're currently involved in on the impact of externalization of border control on children and young people. And as many of you know, then those of you who work on immigration and refugee issues will know, externalization is now a global phenomenon where rich states are outsourcing without consent their humanitarian obligations to neighboring states. So this is true, of course, of the US and Mexico. It's true of the European Union and, you know, first Turkey and now Libya. It's true of Australia with those islands in the Pacific. And so just to dwell on Australia for a second, some of you may be aware that there are generations now of children who've been trapped on these islands, 46 children born in Nauru, and children there who are involved in protests against this really inhumane type of treatment. And this has been ongoing for some years, including children who are suicidal, children who are stitching up their lips by way of protest to show that they have no voice. And of course, there is no access to mental health care. I mean, there's no access to anything very much. But this is an instantiation, I think, of a wider problem that many migrant, refugee, displaced children, apart from needing financial security, access to education and physical health care, also need support for trauma, toxic trauma, which can have lifelong enduring impacts on their mental health and their well-being, and really create disabling forms of illness, depression, crippling anxiety, psychotic disorders. And here again, I think the picture is a very bleak one, that the kind of accommodation, the inclusion needed for people who've undergone these traumas is really not being provided. So even where we have mechanisms for providing some form of schooling, some form of shelter. We're not doing an adequate job of thinking of the mental health consequences of the traumas that these young people have experienced. So to conclude, what I want to say is that we need a more protracted, proactive stand towards disability inclusion than we have so far in many contexts, including in the migration context. Professor Stein and his co-author, Janet Lord, wrote in an article actually now 8 years ago that over 40 million people with disabilities worldwide are refugees or IDPs exposed to increasing hazards during flight and after flight. This dramatic research lacuna of their ongoing health needs, their ongoing physical but also mental and psychosocial needs continues, even though since 2011, when they wrote that article, the problem has only got worse. So I think I'll leave it at that. Thank you very much, Bill.
Thank you. Thank you very much, Jackie. Our next speaker is Professor Jerry Newman. Jerry is co-director of our Human Rights Program at Harvard Law School and the J. Sinclair Armstrong Professor of International Foreign and Comparative Law. Jerry's a great expert on several things, including immigration law and human rights law and international law more broadly. He was, earlier in this decade, for several years, member of the UN Human Rights Committee, and in that capacity was the rapporteur for the Committee on General Comment number 35 about Article 9 of the ICCPR, the Covenant on Civil and Political Rights, and very thoughtful about many of the issues that are addressed in the book that Michael and his co-editors put together. So without further ado, except to note that among Jerry's educational background is a PhD in mathematics, in addition to superb performance as a lawyer and law student. So Jerry, the floor is yours.
Thank you, and thanks to Michael and his co-editors for this magnificent volume. It is going to be immensely useful as a guide to the convention and to the work of the Committee on the Rights of Persons with Disabilities, which is one of the UN treaty bodies, a group of institutions that are responsible for monitoring compliance with what are called the core human rights treaties at the global level. The Human Rights Committee that I was a member of is one of those, and in that connection, we certainly had a lot to learn from the Committee on the Rights of Persons with Disabilities and a fair amount of interaction with the Committee on the Rights of Disabilities. This is a multi-author commentary, and I was interested to see that the authors of the different chapters in some ways took some different approaches to their commentary on the articles. Some of them stay wholly within the frame of the convention and the committee, and are extremely useful in giving a guide to the history of the convention, the meaning of the terminology of the convention, and the work that the committee has done in interpretation of the convention. Some of them add criticism of the work of the committee, which as an academic, I'm always eager to see both description and analysis of that kind. Criticism from the perspective of the scholarly literature, often including scholarly literature that those authors themselves had produced. Some of them add comparative discussion of approaches internationally or at the national level to issues that are similar to the issues dealt with within the convention, adding that additional comparative dimension. And some of those are extremely useful in showing a variety of approaches that exist in the international system. And it's that aspect of it that Professor Stein asked me to address here, particularly in connection with the question about the general comment and deprivation of liberty, and maybe I'll do that a little bit more broadly. One set of issues that is particularly of interest to me is the conception of discrimination that is used in the interpretation of the Convention on the Rights of Persons with Disabilities, and how that relates to other conceptions of discrimination that are used in international law. This is something that I particularly confronted in the context of detention of people who were considered dangerous to others. There is a big dispute which is discussed in this book from an interdisciplinary perspective about what to do with regard to the notion of criminal responsibility and psychosocial disability. There is a movement, in the United States, we may be familiar with a movement to abolish the insanity defense, which is that everybody should go to jail from a crime control perspective. But there's also a movement to abolish the insanity defense from a rights of persons with disability perspective, saying that differential treatment of people on grounds of disability is inherently impermissible, and therefore people with psychosocial disabilities who infringe criminal laws should be punished exactly the same way anyone else is punished. And in particular, diverting them to a system of civil commitment and possibly treatment, that's a violation of their rights, and it's a violation of their rights in principle, regardless of how it's carried out. Not merely that there are abuses in the institution of civil commitment, but that the very idea of civil commitment should be abolished. This is consistent with the committee's general treatment of the issue of discrimination on grounds of disability, which is that intentional unequal treatment on grounds of disability is always forbidden. That's different from the usual international understanding of discrimination, which is that differential treatment, which is intentional, is subject to a standard of justification. And that standard of justification may be a very high standard of justification. And one of the great achievements that the Convention has had and that the committee has had in the human rights system more generally is to increase the level of justification that is being demanded by the European Court of Human Rights, by the Human Rights Committee, by other bodies with regard to differential treatment on grounds of disability. But the committee has had less success in persuading other international human rights institutions to adopt an absolute rule that there can be no justification and that differential treatment on grounds of disability is never permissible. This was a subject on which, when I was on the Human Rights Committee, we had active conversations with civil society, with disabled persons organizations, and active conversations with members of the Committee on the Rights of Persons with Disabilities. But it's a subject on which ultimately we sort of had to agree to disagree. That for their convention, they maintained one interpretation, but that we were going to continue to maintain an interpretation that there would still be a question of a level of justification. That that there might be people who were sufficiently dangerous to themselves that they needed to be rescued from suicide, and that they needed to be temporarily deprived of liberty in order to prevent that, that there would be people who might be suffering from such extreme dementia that they should not be living in abodes with permanently open doors that they could wander from whenever, in whatever temperature, dressed however they were. And that there were some people who were so dangerous to others that they needed to be deprived of liberty, subject to numerous procedural safeguards and limitations, but that they needed to be deprived of liberty. There may someday come a time when the insanity defense can be abolished, when there is a new conception of criminal responsibility, when there is a new conception of how to deal with the problem that has led to the continuation of civil commitment in that way. I would say the committee has not yet come up with a solution to this problem as to what should be done instead. And until the committee comes up with that solution, or someone else comes up with that solution, we will find that other human rights institutions, including the European Court of Human Rights, as it does, including the Human Rights Committee and others, will continue not to be able to subscribe to the absolute prohibition that the Committee on the Rights of Persons with Disabilities ascribes to. That was the nature of the debate. Thank you.
Thank you, Jerry. Our third commentator is Professor Ruth Okoboji. Professor Okoboji is the Jeremiah Smith Jr. Professor of International Law, the same general universe as Professor Bhabha in terms of title, and co-director of the Berkman Klein Center. Professor Okoboji has an illustrious career. She was really central to the negotiation of the so-called Marrakesh Treaty regarding access to copyrighted materials for persons with visual impairment. She was appointed by Ban Ki-moon to the UN Secretary General's, get the title right here, a high-level panel on access to medicines, which she played a very important role. She's an author of a tremendous number of articles about copyright and a book, more than one book. The most recent one, Copyright Law in an Age of Limitations and Exceptions, 2017. And my fun fact for Professor Okoboji is my first day teaching at Harvard Law School was her first day as a student at Harvard Law School 30 years ago. And to this day, we continue to debate who was more scared. I am certain I was, but I was saved on innumerable occasions during that class by her brilliance. So the floor is yours.
Thank you so much, and let me just say congratulations to my dear friend, Professor Stein, for this remarkable book, and you and your co-editors have done really a Herculean task, and it's a gift to my field, intellectual property, it's a gift to the human rights field. Professor Stein has asked me to speak on this issue of the Marrakesh Treaty, which is near and dear to my heart. So I want to start. How many people here have actually ever been to Marrakesh? All right. So the Marrakesh Treaty is interesting. So I was privileged to be a part of the negotiations. It happened and we finished the last bits of it in Marrakesh. So I can say I've been to Marrakesh. I'll have to come see those of you who've actually been there to come figure out what Marrakesh is really like, because I was just stuck in a hotel room for hours on end and never once made it out of the negotiating venue. So It was a miracle indeed, is what the Marrakesh Treaty is often referred to. So this is not an intellectual property crowd, and so I'm assuming many of you are wondering, why do we care about intellectual property? Before I do that, let me just say that on January 30th of 2019, President Donald Trump signed the final papers, and the United States ratified the Marrakesh Treaty. So for those of you who have been concerned that multilateralism was dead, this is at least some glimmer of hope. It is a treaty that is historic on so many fronts, and I'm going to jump, because of limited time, to speak about why it's relevant and so critical to the work that Professor Stein has just completed. For many, many years, the blind community around the world has been engaged, or had been engaged, in collective action to end something called the Book Famine. The what? The Book Famine. Less than 10% of visually impaired persons in the developed world, less than 10% of published works in the developed world are available in accessible format copies to visually impaired persons. And for those of you who have had the privilege of having to wear glasses or contact lenses, I want you to imagine a world in which you did not have contacts or glasses, and therefore, for every book that you had to read, every class you had to attend, you needed either enlarged font on the screen, some sort of technology to enable you to access educational materials or books to read. Access to cultural works, access to education, access to information, the things that sighted people take for granted on a daily basis, were implausible, if not impossible, even in the developed countries for many visually impaired persons. In the developing world, less than 1% of published books are available in accessible format copies to visually impaired persons. I, for the first time, about 15 years ago, had a law student in my class who was completely blind. And for every week's worth of material, my student would be at least 5 weeks behind. That's how long it took to take the material and to turn it into an accessible format copy for her to be able to keep up with her school materials. Situation is a bit better today, but not much. And this was creating what we call the book famine. In other words, if you think about what it means for a non-sighted person to be able to go to school from kindergarten without their materials in accessible format copies, to be able to be in a work environment and not be able to have work materials in an accessible format copy. As a result, most non-sighted individuals, a great percentage, never finish school. Many are underemployed. The average use of iPhone apps, almost inaccessible, and on and on and on. Now, this condition, the book famine, which is not limited to books, as I've just said, embraces all kinds of creative content. This condition was exacerbated by two things. First, copyright law precludes the changing of creative content into different formats without the permission of the copyright owner. There was no way to do that. Second, copyright law precludes the cross-border transfer of copyrighted materials without the permission of the copyright owner. The US is home to the largest library collection store of accessible format copies, over 550,000 accessible format copies available in the United States, but could only be accessed by non-sighted people in the United States. It could not be shared with non-sighted people around the world. And so that meant, you can imagine, because the right of translation is also a right that belongs only to the copyright owner, if you were a Spanish-speaking, Spanish-reading, non-sighted person getting works in accessible format copies that you could access, and this includes audiobooks, ebooks, was doubly problematic. And so even though Mexico has a library of materials for non-sighted people, it could not export those books to the United States for Spanish-speaking people and vice versa. And so the copyright system, because it's territorially bound, had these rules that made accessible format copies inaccessible to sighted people around the world. And even if you were in the same country with large libraries, there were other technical barriers to accessing these. And so the Marrakesh Treaty, for the first time in the history of intellectual property, creates an exception to the rule that copyright owners control the rights to change creative expression into an accessible format copy. It creates an exception. That in itself is a miracle. If you know anything about intellectual property and intellectual property politics and the political economy of intellectual property lawmaking, limitations and exceptions to copyright or to any form of IP is the exception, not the rule, no pun intended. But the Marrakesh Treaty did something more. And if you look at the CRPD, and in particular the volume that we are celebrating today, both in the critique and in the celebration of the CRPD, the whole idea, as Jackie has mentioned, is equality. The notion that persons living with disabilities are entitled as a matter of human rights, as a matter of protecting human dignity, to the same opportunities. It's a principle of equality. It's a principle of dignity. And what the copyright systems and intellectual property systems did, because intellectual property is viewed as a private right, there's always been concern about how do you create exceptions to something that is someone's property? How do you, encourage the private sector to make these works available in accessible format copies? And the problem, of course, is there was no scalability. I mean, it didn't make any economic sense in the minds of many publishers to transform their works into accessible format copies. And so you had an entire population that was not being served, and yet legally, no one else could do it, and even the communities of non-sighted people could not transform these works into accessible format copies. And so the Marrakesh Treaty creates an exception to copyright laws and makes it mandatory. So it's in all of international copyright law, limitations and exceptions, libraries, archives, museums, it's a may. Countries may establish limitations and exceptions for libraries to hold, materials or to make photocopies. Countries may establish exceptions and limitations to copyright for educational institutions, to use. Countries may, right? For the first time, countries shall. Countries shall adopt mandatory exceptions to copyright, to the right of reproduction in particular, the right of distribution, so that individuals and authorized entities can now make accessible format copies of published works. It is a major shift in the modalities of international copyright law. It is a major shift in the design of international copyright law. And it is the first time that human rights and intellectual property have essentially been tied into one multilateral instrument. For the United States to have ratified this treaty, and frankly, a former Harvard Law School a student, a graduate of Harvard Law School, Professor Justin Hughes, who led the U.S. delegation in the negotiations, myself, coming together to negotiate in a way that would be acceptable to the content industry, to Hollywood, and to politicians was remarkable. And of course, this is squarely in the framework of the CRPD. The CRPD recognizes, of course, rights to information, rights to access to scientific and technical materials, in addition to the general notion of dignity, the ability of non-sighted people to go to school, to receive their materials in an accessible format copy, to not have to wait. The average wait time for a sighted person, for a non-sighted person to receive an accessible format copy of a book, just a novel, was typically anything from 12 to 18 months after sighted people had them. And it seemed like in every socioeconomic sphere, the barriers for non-sighted people were quite significant. And today, not only do non-sighted people have this right, not only do countries have to mandatorily provide an exception to their territorial copyright laws, it also facilitates the exchange between countries. So that today, you can in fact import an accessible format copy from France to Burkina Faso. You can import an accessible format copy from Germany to the United States. And we are now seeing for the first time non-sighted people around the world using the language of the CRPD, the mandatory tools of the Marrakesh Treaty, to begin to see a level of equality build across educational institutions, cultural institutions, and of course in the private sphere as well. I want to just say a few more things, and I know that my time is up, but I just want to say two things that I think is really critical. The Marrakesh Treaty, once it's created these positive rights, actually does a number of important things. It helps countries implement the CRPD. In other words, merely ratifying the Marrakesh Treaty is one of the important steps of implementing and bringing to fruition the expectation that social and economic rights associated with cultural goods become part of the mainstay for non-sighted persons. And just so you know, the treaty did not stop in making these exceptions mandatory for countries just for blind people. The definition of a visually impaired person for the first time actually does more than I think most people expected when negotiating the CRPD. So persons with dyslexia have the exact same rights. The CRPD does not prescribe this, but we thought during the negotiations it was very important for people in poor countries not to have to take expensive medical exams to verify that they are non-sighted. And so the language used is reasonableness. If you were told, for example, that your non-sighted status could be corrected by surgery, you could still enjoy the rights granted under the Marrakesh Treaty without having to take the surgery. There's no obligation to undertake corrective surgery, even if that surgery were available. And we thought this was important because so many people in so many poor countries around the world simply can't afford a pair of glasses, much less corrective surgery. And so everything from needing glasses all the way to full blindness is covered by the Marrakesh Treaty. And that, of course, squares rightly with Articles 19 and Articles 32 of the CRPD. Now, the volume that Professor Stein and his co-authors have produced is both critical, aspirational, and reflective. And I think that as we begin to see countries work on many of the recommendations, the analyses, and even respond to some of the criticism, what the Marrakesh Treaty and the CRPD intersection does is to show us that there are tools and there are mechanisms and there are methodologies that make human rights not just an adjunct of public law, not just a field that we can study, but a set of rules that have legs and feet and that can have an impact on those who are the most vulnerable in the global economy. Thank you.
Thank you. Thank you, Ruth, and your work really was amazing. So we'll turn to this point to you, Professor Stein. I can't tell you what a joy it has been to work with him over the last 15 years. When we together established the Harvard Law School Project on Disability, and Dr. Cui-Fang Ming and Alonzo Emery from our project are here. And it's just so gratifying to have the opportunity to work with Michael. Michael graduated at the top of his class at NYU, is on the Harvard Law Review. He has a PhD in history from the University of Cambridge. He has won more awards than I can possibly remember, just to mention a few. The inaugural Viscardi Award, the inaugural Ruderman Prize, the Hearn Prize from the American Bar Association, and one could go on and on and on. He's published everywhere, Harvard Law Review with Professor David Wilkins, Penn Law Review, Duke, Michigan, Chicago, many others, on a range of different topics and different voices. I mean, it's really a polymath. Just one last comment. It's such a treat to work with Michael because if we go, for example, to China and somebody asks a question from the relevant ministries, of course, Dr. Cui Fengming is the one who knows the most about China, but Michael can say, well, here's 26 ways it's done around the world, and here are the kind of predicates and the assumptions and the historical contingencies. And, you decide what fits your country, but here's a panorama of institutional design. I mean, the encyclopedic knowledge is staggering, and I guess the book demonstrates that in part. So, Michael, the floor is yours.
Thank you, and I'll try to stay brief so we can take some Q&A, and I know that people are heading off back to class, and I'm grateful to everyone for appearing. I'm grateful to the Human Rights Program and to HPOD for co-sponsoring, to the three marvelous panelists who are marvelous academics and marvelous friends for making time and contributing to this, to our chair, who I get the privilege of working with every day and learning from his wisdom and kindness and great erudition. It's 15 years and it doesn't feel like it. It's been absolutely wonderful. And to the library, it was wonderful for you to sponsor the talk, but even beyond that, every day I benefit from the wonderful support that I get from HLS Library. And they're not only the best librarians in the world, they're also incredibly nice people. So thank you for that. I pass on regrets from Professor Bantekas, who is somewhere between Doha and Logan Airport, in theory arriving to the Kennedy School class tonight, but we'll see about that. Most of our work at HPOD has been not on this sort of book. In the 15 years since the CRPD has been wrapping up, and in that time, I've, for better or worse, written more on disability law than anyone. Not for me to decide if it's good, bad, or indifferent. But most of our work actually is in reaching out in plain language on educational materials with persons with intellectual disabilities, particular disability groups, non-English speakers, providing guidance to UN agencies, whether it's DESA, thinking about the interrelationship of the Sustainable Development Goals and disability, or whether it's working for many years with the World Health Organization on their toolkit for mental disability and mental disability rights. But most of our work is with civil society. This is not a book for civil society. This is a book that fits within the Oxford Handbook scheme of how do you write a treaty commentary. And I was very grateful to Ilias and to Dimitris, my co-editors, for inviting me in and in doing much of the heavy lifting. I know that I've read it all. I don't remember all of it. I do know that we had lots of discussions about, as Professor Alfred pointed out, having cross-disciplinary approaches to it, but also within the legal field, we purposely went outside of the usual suspects on disability law and policy, of which there is a cohort of whom we all know each other and managed to arm twist each other to contribute to various publications. And there's, I think now this is the 6th book that I've done, but we purposely wanted to reach out. And that was somewhat inspired by a talk that Martin Shannon did at a conference when he and I were doing sort of competing keynotes, me about what it was like to negotiate the CRPD and the insights to it, and he, from an international law perspective, where are the gaps? And how does he read it as an outside person? And I thought that was amazingly helpful. But among the 60 or so people who contribute to this volume, we've also included not only international law experts who don't do disability, but also junior individuals to try to encourage them into the disability field. They may not have considered that their work overlapped with it, but now in reflection, maybe they'll do more work on it. And some very talented PhD students as a way of empowering and engendering the next generation of people to work. We took a decision not to have a right or wrong basis to the individual chapters unless something was really wrong, as in empirically wrong, and that didn't happen too often. There were lots of places where we actually disagreed with the perspectives of the authors, and our approach was we don't want to micromanage that way, and we don't want to control. We want freedom of academic expression and perspectives, and let it go out there. let it do that. So there is no disability rights party line or polemic that runs through the treatise, which no doubt will get criticized by my friends in the disability rights movement. As for the individual panelists' wonderful presentations, Jackie, while you were speaking, I was thinking about being on the other side of Bangladesh with the Bahari refugees, who've been there since the revolution of 1971. And persons with visual impairments continue to fall into open sewers in the refugee camp. When they come by with daily employment trucks, it's always the disabled folks who are last to get there. And the real life implications of it are heart-rendering, especially as to speak personally, for people like you and I who are not only human rights people, but also from families of Shoah survivors. So seeing people who are refugees installed and trying to get to the next place and being empowered. And of course, there's a brighter side to it, which, the Za'atari camp in Jordan is the exact opposite on inclusive education and on disability inclusion. So there are good prospects, but there are many of these really difficult situations that remain. Jerry, you were extraordinarily gentle in your comments, for which I thank you. I engaged in many knockdown, drag-out fights with the disability community during the negotiations on Article 12 in legal capacity. I lost them. I represented at least 3 different delegations as their legal person and did not permit them to sign on to that representation of Article 12, the everyone always can decide with sufficient support, because I didn't think it was legally, practically real. Those got overruled. They went in politics and got the delegations to say, thanks, lawyer, but no thanks, and we're going to sign on to it. The CRPD committee, I got into fights with various members who are friends during the drafting of it and tried to point out the errors in it. I lost. The UN has taken it on, through the High Commissioner's interpretation. I tried to persuade her that that was wrong, and I lost. And now we're in this really difficult place where we have a fundamentally progressive, if you like, or fundamentalist, if you don't like, view of what legal capacity is, and states that are trying to reform their mental health laws for the right reasons, and doctors who want to be human rights agents but are at the point of contact in emergency rooms and elsewhere don't know what to do. And we continue to have these quarrels, as Vikram Patel and I have organized a conference to have a safe space and a dialogue on it, and we still are having quarrels with some of the individuals as to whether they will attend because they want to know ex ante what the positions that will come out with are. And we've said, no, we want an open dialogue because that's what an open dialogue is. So I hear you, and I appreciate so much the HRC engaging with the CRPD committee, even if at the end no one was fully satisfied. And Ruth, my goodness, it was so much fun doing those workshops with you and Larry and Molly, and hearing about your experiences in the Marrakesh Treaty. And I was at the National Federation of the Blind 2 weeks ago. I haven't been there for ages, and I did their keynote, and they are so excited. They are so excited because for years they have said that technology, which they had looked forward to for years and years, has wound up in many ways excluding them more than they had been excluded before. And they don't understand why the Kindle is not accessible. Right? And even after they lost, $15 million because of Secretary Clinton, and the contract that she voided with the military. And they can't understand why it is that the copyright holders are holding on to that. And I was without attribution on the brief for the Hathi Trust. And that's the big Google Docs, which is going to change everything about accessing literature and documents. So the world is improving slowly, but never fast enough. Never fast enough. And the hardest part of doing the real work, the field work on the CRPD, is that you go to places where people's lives are not what they should be, and you want them to be better, and you tell them in all honesty that it will take time. And then you get back on your business class seat and fly back to your privileged developed nation where you have accessibility and very expensive accessible technology like the one I'm sitting on That's tough. That's tough. But we do see light. We do see improvements. We now see, because of this treaty and the way it's been applied, uniform application across the UN system, focal points in every UN agency, action to make disability included across it, and the last peg that I think, and this goes back to our love of development, is the World Bank now including disability as part of their safeguard protections. So for the first time, at least technically, that $160 billion a year that goes out in loans and semi-loans has to pass muster on what are you doing about the largest minority group in your country. So I think the prospects are terrific. So thank you all for contributing to this, and I'll turn back over to our chair.